This is on a motion for reconsideration of the board's denial of a mandamus. Is that correct?
Correct.
Okay. Thank you. You may proceed.
Hey, may it please the board, good morning. My name is Jennifer Jasper. I'm a partner with Gaines West in the firm West Webb Auburn and Gentry. Unfortunately, Gaines could not be here to hear this motion himself. We were only recently retained by our client, Mr. Charles Davis, who's here with us this morning. We filed a notice of appearance just last week, and we are here on the motion to reconsider. The motion to reconsider was filed with the board on October 9th, subsequent to mandamus relief, which Mr. Davis had sought from this board and which this board had denied. Now, the mandamus relief he sought concerned a recusal motion that he filed with his evidentiary panel prior to his evidentiary hearing. At the time he filed his original mandamus petition and the first amended, the record was unavailable of the evidentiary proceeding. So once he obtained that record, he subsequently included it with the motion to reconsider. So now we do have the testimony that's relevant to that recusal motion, and that has been submitted to this board as well. The motion to reconsider, as I said, deals with this underlying motion to recuse that Mr. Davis had filed at his evidentiary panel proceeding. Now, let me give you, without going into the details of the procedural history of that grievance case, there's a few things that are important for the context here. The grievance against Mr. Davis was filed in 2011, so about more than 4 years ago. It was filed by other lawyers, and Mr. Davis has always denied the allegations against him in that case. After there was some initial activity in 2011, between September 2012 and January 2014, there was no activity to prosecute the grievance, to set the hearing, to do anything. As far as my client knew, this case had sort of fallen off the radar. And he didn't have any reason to believe that this was something that the bar was seriously going to aggressively prosecute. However, yes, in January 2014, just this year, they appeared to want to prosecute it again. And apparently there had been some problems getting a panel in place and securing a chair. From my brief review of the proceedings below, there have been 6 different chairs appointed for this evidentiary panel for various reasons, some of which were never really explained to Mr. Davis. A couple of folks recused themselves, but he has had more or less a rotating system of panel chairs that have come in and out of his panel. In any event, when the final panel chair, Mr. William Altman, came on probably within a couple of months before the hearing date, it's not clear to me from the record, this is where we get into this recusal motion that Mr. Davis filed for himself. Now, a few things about recusal. Recusal law is fairly well settled. It's not a new area of law. There's not a lot of new developments in recusal law. It can be summed up in 3 words: recuse or refer. That's it. That's when a judge is faced with a recusal motion. Those are the 2 options, and those are the only 2 options. Option number 1, grant the recusal. If a judge grants the recusal, another judge is assigned to hear the case from that point forward. Option number 2, you don't want to grant the recusal, okay. In that case, you refer. The rules of civil procedure have you refer to the regional administrative judge, who then will assign another judge, or he himself might do it, to hear the actual recusal motion. If the recusal motion is denied, everything goes on with the original judge. Now, for the last 35 years, this has been the law in Texas: recuse or refer. Beginning with the Supreme Court decision that Mr. Davis cited in some of his briefing, McLeod v. Harris in 1979, and up through a very recent opinion we found involving Judge Shipman up in Denton County in October 2014. The reasoning behind recuse or refer was clearly articulated in an opinion by the 14th Court of Appeals in a case Johnson versus Punjabi, also cited in Mr. Davis's briefing. And I'm going to read from that opinion. One of the most fundamental components of a fair trial is a neutral and detached judge. The impartiality of the judge is not only a matter of constitutional law, but of public policy as well. How the system handles motions to recuse goes to the very heart of the promise of impartiality. Thus, the purpose of the recusal rule, as noted in another opinion, holding the same way by the First Court of Appeals, is that you want to distance the challenged judge from the recusal proceedings so that you can afford a neutral arbitration of the movement's complaint, especially when there is an accusation of personal bias. Recuse or refer. Now, there are some basic procedural mechanics that go along with implementing recuse or refer. Number one, the presiding judge has 3 days to make that decision. Number two, if they decide to refer, it goes to a regional presiding judge who then can either hear the recusal motion him or herself or refer it on to another judge. And number three, if that recusal is verified and is filed before any evidence is offered, the challenged judge can take no further action on the case until the motion has been decided. And if the challenged judge goes ahead anyway and decides to make rulings even after a motion to recuse has been filed, those rulings are void. Now, let me give you a couple of examples, because there's plenty of them in the case law. In a case that came out of the Dallas Court of Appeals, we had a movement who filed a motion to recuse at pretrial. Judge orally denied it about 30 days later, right before trial, went ahead and tried the case. The whole case was taken up on appeal, and the first point on appeal was the denial of the recusal. And the Dallas Court of Appeals reversed the entire judgment because the judge failed to follow the recuse or refer rule, and thus her subsequent orders at the trial were void. And notably, the appellee in that case made an argument, well, this motion, the judge was free to deny it out of hand because it was procedurally defective and substantively defective. That was the argument on appeal. And the appeals court considered that argument and said, and I'm going to read from this opinion, the court has previously held that a trial judge, when presented with a recusal motion, regardless of the procedural sufficiency of that motion, has the option to act in one of two specified ways: to recuse himself or to refer the case to the presiding judge. And this part's insightful. We do not hold that the motion is free from scrutiny by some other judge, named in obedience to the rule and the statute, but we do hold that the judge named in the motion may not do so without violating his plain duty. By pursuing an option unavailable through any law or statute, the court abuses discretion as a matter of law. So if a judge decides to pursue an option that's not either recuse or refer, they've abused their discretion as a matter of law. Same thing happened in the N. Ray Norman case, which is that recent case that I mentioned that was just decided in October. Coincidentally, it also involves some people out of Houston and Judge Mike Wood. Mr. Norman filed a motion to recuse Judge Wood. Judge Wood referred the motion immediately to the regional presiding judge, who assigned it to Judge Austin. Judge Austin gets the motion to recuse, but before he can consider that, the plaintiff files a second motion to recuse Judge Austin. Well, Judge Austin took it upon himself to rule on that second recusal motion, and he said, I'm not going to recuse myself. I'm denying it. I am going to consider the underlying motion to recuse Judge Wood, and I'm denying that too. The petitioner in that case took it up on Mandamus to the 14th Court of Appeals and was awarded conditional mandamus relief by the 14th Court of Appeals. Because, why? Because Judge Austin was not free to ignore the statutory duty to either recuse or refer the motion Once the motion to recuse Judge Austin was filed, he was precluded from taking any other action than either issuing an order of recusal or an order referring. Thus, his order ruling on the motion to recuse Judge Wood was void. Again, in that case, the real parties in interest complained there were substantive defects with the motion to recuse, there were procedural defects with the motion to recuse, it wasn't timely, but that was not sufficient, according to the 14th Court of Appeals, to ignore the recuse or refer rule. Quote, even though a motion to recuse may be defective, the challenged judge must either recuse or refer the motion so that another judge can determine the procedural adequacy of the merits to recuse. This is the proper, I'm sorry.
Are there any exceptions to the refuse or refer rule that you're talking about?
I believe in the CDC's briefing, they have brought cases where people did not present verified motions. And an unverified motion, there is some case law to suggest that an unverified motion might be all right for a judge to just deny out of hand.
What about the timeliness of it? It appears to me that this matter was set for hearing on September 26th and it was filed on the 25th.
That's correct. That's
Is
correct.
there a timeliness issue here as far as you're concerned? I think the CDC thinks
They have argued that there's, under the rules of civil procedure, it's 10 days or as soon as you know you're going to need the relief, as soon as the occurrence that gives rise to your need for recusal. And there are lots of cases when that same 10-day rule has been argued by one side, but typically appellate courts are reviewing it. If there is an underlying reason why the person couldn't get it on file 10 days before, they will not let that.
Was there a
Let me
reason
ask you, right, part of the request for mandamus relief recited, I think accurately, that mandamus is not used to resolve factual disputes. And I'm hearing you suggest that there may be factual reasons to excuse a 10-day compliance, but those would not be apparent on the face of the record or without potential dispute. Doesn't that help us understand why the cases you've talked about came up on appeal rather than by mandamus, and that mandamus is simply the wrong vehicle, that for all we know, Mr. Davis may be correct in his belief that there should be a finding of no discipline, that the panel proceeding may find no discipline, and this would be an academic matter. What's the reason for the mandamus relief, and why does that not involve some examination of facts rather than of a clear abuse of discretion?
The case law is clear that mandamus relief is available in a situation where a judge either refuses to recuse or refer, just like it was in the case that I was just citing to you.
But in that one, it was filed 30 days in advance, so there was no timeliness question and no factual inquiry necessary concerning reasons for an arguably untimely motion.
And as part of, if I can amend part of this question, if you'll, what was the basis for it? Why did we wait until the day before? What was discovered that made this necessary?
Here's what I would say. The merits of the underlying motion isn't before the board. And because we were only retained recently on this case, that we have looked at prosecuting this motion for reconsideration, the underlying motion for recusal. But I would suggest that would go back to the same complaint that courts of appeals have objected to in terms of, I don't think your substance was there. I don't like the substance of your motion. I don't think you procedurally complied with what you were supposed to. Those are not free from scrutiny. They should have been scrutinized by somebody other than the panel chair who my client moved to recuse.
And is that not a perfect point of error if the proceeding proceeds and there's a finding of discipline, of sanction, and a desire by your client to proceed? Isn't that, if Mr. Davis is correct, that this was procedurally improper, why is that not an appellate point just as in other cases that you described?
It could be an appellate point, and if he decides he wants to appeal the final judgment,
And the
he
flip
can bring
side.
that up on the final judgment.
The flip side is the record we have here as you acknowledge quite candidly and appropriately, that this record gives us no understanding of the circumstances that existed. You were not the author of the motion and your firm was not, but if you had written the motion, it would have asked to recuse the presiding officer. This one never says that. It's really, as much as anything, the prayer asked to examine why did prior people recuse themselves. So it seems to me that this is one that's a very one-off set of circumstances and motion. Why is it your view that mandamus should be the vehicle and that there's not an adequate remedy by appealing afterwards?
First of all, the motion itself does ask for recusal by citing the very rules that deal with recusal, that 18A.
It cites the rules.
While there very well may be different ways to interpret what other relief Mr. Davis may have been requesting in that motion, there can be no question that recusal was one of them. And this record that we've tendered to the court from that proceeding below, here's what happened. The chairman, who he had moved to recuse, said, all right, let me first say, yesterday afternoon I received a pleading entitled TCRP Rule 18.1 motion. Do you wish to be heard on that motion? He said that to my client, and Mr. Davis said, well, it's difficult for me to answer that. 18A sets out a procedure. It's not my intent to go around that procedure. The duty has passed from me by making the motion. It's now part of your charge to respond to it. And he goes on to say, I do believe that regardless of how anyone feels about the motion, whether it's proper, improper, timely, untimely, the motion requires a procedure to commence upon notice. So he's telling this to the chairman. He says, it is incumbent upon you, Mr. Chairman, to do certain things once a motion like this is filed. Now that to me means you have to either recuse or refuse to recuse, and then you send notice to the regional presiding judge. So he's trying to tell him, I think these are the rules that need to be followed here. And the response from the chair is on page 8 of this transcript. It's on page 7. Mr. Davis and Mr. Holt, for the record, the pleading that was filed yesterday, which I understand to be a motion entitled TCRP Rule 18, Rule A, Rule B, is denied.
What's your view of the validity then of the subsequent judgment of disbarment?
We would argue that following all of the case law, that judgment is void.
And if you raise that on appeal, that would be the appellate point.
Correct. The chairman said when my client at this proceeding brought up the problems that may arise if he continued to move forward, his response was, Mr. Davis, with all respect, I've denied the motion. We're going to proceed. And Mr. Davis says, quote, if you go forward, everything from this point will be void if you don't do what is required. It will cause a huge difficulty. This was set out for the chairman. And his response was, I listened to your viewpoint. I've overruled your motion. I disagree with your statements, period. They're not correct.
I think you're telling us, and I get that the law is clear that once a recusal motion is filed, and if it's not referred out, that anything that's done. I get that, but I'm not sure I've heard an answer to Mr. McKetta's question, because again, if this is appealed, I assume that we will consider at some point the issue of whether it was void. I understand that, but tell me why mandamus should issue.
Because you can have the chairman go back and do the right thing. You can have the chairman now go forward and enter, if he's not going to recuse himself, enter a referral. And from that point forward, a proceeding that could take place that was proper.
But you could do that on any time that somebody complains about a procedural aspect of any hearing, and we don't have interlocutory proceedings ordinarily if there's an adequate remedy. So what is the inadequacy of the appellate right?
Well, maybe I can make a distinction to make this clear. Okay. Certainly, there have been cases which have considered this issue as part of an appeal from a larger judgment, and I'm not going to argue that my client can't do that in this situation if once a final judgment is rendered and once he receives it, that he could consider that as one of his points of appeals. But in any event, the case law is clear that this remedy is available when they don't pick only the one of the two options available to them, either recuse or refer. And, you know, I keep going back to the cases that all have said, you don't need to wait till a final judgment to seek a mandamus, to force the judge to do something that his failure to do is an abuse of discretion.
If
So-
there are no fact questions. I thought we talked earlier that here the circumstances, you had said there were facts you did not know because they're outside of this record.
Well, the substance of the motion, I said I didn't want to get into the substance of the motion today, but in terms of the facts that are necessary for the appeal, the only facts that are necessary for the writ of mandamus are, one, he asked for it before evidence was introduced. And
He
that's
asked
clear from the record.
But he asked for the relief that he
Correct.
swore to.
Correct.
The relief he swore to does not say, the relief he swore to does not say, I'm asking this chair to recuse himself.
I think that you could, if that wasn't expressly stated in his relief, you can certainly infer that from the rules that he refers to.
The relief says, I'd like an inquiry on why there were earlier recusals over the past months. You might not remembering correctly
No,
what the
he
relief,
said
the
that,
verified
and-
relief.
Yeah, and I would agree that by raising those other motions, it might not have been crystal clear that the intent of the Rule 18 motion was indeed directed to the panel chair. Because if you look at Rule 18, it only deals with recusing a judge. So the only recusal that could have been captured by the title of that very motion was the challenge to the judge, who in that case was the presiding chairman, Chairman Altman. Now,
Can I ask you a question?
yes, ma'am.
Looking at this without going any further past just the bare facts, it really looks a little bit like Mr. Davis was just trying to be obstructionist. And he's filing this on the eve of the hearing. It doesn't say he's asking for the panel chair to recuse himself specifically. He's asking for an inquiry as to why other people recuse themselves, and who knows why that matters to Mr. Davis. But looking at it from what you're telling us now, and I get the rules of proper motions to recuse. But he also says, in where you've pointed out in the record, that he expects this to be referred and someone to make a decision on whoever's he wants to be recused. But then he couples that with, then he wants to transfer the hearing to a whole nother district, and now we're gonna start this all over again. So, if I'm following your logic, even if Mr. Altman had done exactly what you're saying he should have done, and I don't read that in the motion, but I'll go with it. Then we have this referral, we have this hearing, that's decided, and then when we get back to, now we're getting ready to have this evidentiary hearing again, and now Mr. Davis wants to transfer the case someplace else after we've been through that exercise. So, I mean, I understand what you're saying. I don't think that it speaks to the original question that Mr. McKetta asked you about the timeliness of this, coupled with the obstructionist nature of what is happening.
Let me see if I can address your question. There have been concerns, as expressed in all this case law on here, where people raise your same concern and say, this motion to recuse is just one in a number of steps this person has taken to try to avoid what's coming to them, basically. It was obstructionist. It was improper. The rules actually provide for a sanction against somebody for bringing an improper motion for recusal. So what the courts have done when faced with that argument is said, well, it might have been, obstructionist or abusive, but you can seek relief for that under this other provision of Rule 18 that says if you think a motion to recuse was improperly filed for an unjust reason, there weren't sufficient substantive report, you can come back and get sanctions for that. So those are sort of built in to disincentivize people from filing unmeritorious motions. Now, there was a motion to transfer venue filed around the same time. I understand that is not before the board today. I don't know if the board's going to take that up at some later time. Perhaps if it were transferred, that would moot this whole issue about whether we need to recuse the chairman, because we'd have a whole new panel in place. But without that issue being before the board and being decided first. All that's really here before the board is this motion to reconsider the recusal issue, which we think is pretty clear based on all the law.
Doesn't that procedure that you just outlined the last couple of minutes, wouldn't that cut against the logic of mandamus or interlocutory orders, because that all entails the development of a record which can then be reviewed on appeal?
I mean, once again, it's crystal clear from the case law that this type of abuse of discretion, when you fail to follow a mandatory statutory duty to recuse or refer, it's appealable by mandamus.
But yet we still have to make inferences on the motion in order to get to the place where we can make that decision, do we not? In other words, Mr. McKetta told him, well, it's not really what the motion says. And I believe you said, well, you can reasonably infer. That's what so we're going to have to make an inference, are we not, in order to get to the point where, under your argument, we could grant mandamus.
I don't think in this case, like I said, the title of the motion refers to the Rule 18 and the rule procedure that is dealing with one thing and one thing only, which is recusal. So I don't think there can be a mistake. I agree, there is other language in there about recusing other people and other forms of relief, but all there needs to be is that recusal motion. It's there, it's verified, and it was obviously made clear before any evidence was introduced that this was what he was trying to do. He could not have been any more clear to lay it out to the panel chairman at the time in terms of what he felt like the panel chairman's obligations were. So I really don't think there was any question of, am I under an obligation to recuse or refer? Because Mr. Davis made it really clear to him at that hearing, if it hadn't already been clear from the motion itself. In any event, there were some briefing.
Can I ask you a question? Let's assume all that it was clear that he was being asked to recuse himself. Is it an abuse of discretion if he doesn't file it timely and the panel chair denies it?
Is an abuse of discretion?
So I'm trying to find out what the abuse of discretion is. You're telling me that he had no discretion. He had to
Recuse or refer.
Okay, but it also had to be a timely motion, isn't that right?
There is a timeliness requirement, but as the case law supports that I talked about earlier, those sorts of complaints about, is this timely, is this substantively sufficient, those all also need to be taken care of by the reviewing judge.
I understand that, but for mandamus, it's a discretion. He has to have abused his discretion, and all I'm saying is, for purposes of mandamus, I'm not talking about the ultimate ruling whether there should have been a recusal or not, and the voidness and those arguments. But if it's filed late, isn't it by its nature a discretionary act at that point, whether to grant it or not?
It would still come down to that assessment of whether it's really late or not, because there is a provision that says you can file in less than 10 days under these particular circumstances.
Do we have facts that would justify that? I'm just trying. It seems like to me we're way ahead of ourselves because we don't, and I think Mr. McKetta has said that. It seems like we're way ahead of ourselves. You may have a very good appeal,
right,
ultimately.
Well, I would
but
suggest
is it at this time? That's
we're not ahead of ourselves because the substance of the motion was not something that Chairman Altman should have been considering. He's not considering the substance of the motion. He's looking at the motion. Is it a recusal motion? Is it verified? Is it presented before any evidence? And if you can answer those three questions, it's recuse or refer.
So the 10-day rule doesn't apply?
I'm not saying the 10-day rule doesn't apply. I'm saying there's exceptions to the 10-day rule. And whether or not those exceptions have been met,
doesn't that fall within the discretion? That's all I'm trying to find out.
I would argue that it does not, because that belongs to the discretion of the judge who is going to review the underlying motion to recuse.
I've got a question. Is it your position that, and do you have any case law that 18 and 8A and B apply to an evidentiary panel as opposed to a judicial tribunal?
Right. There's no particular case law, but there is Rule 206 in the disciplinary rules of disciplinary procedure that specifically mentions recusals in the context of an evidentiary proceeding, and it says that we are going to treat those recusals just like we would in a district court setting.
Where is that?
2.06, assignment of committee members. And I would argue that, you know, this was an argument that the CDC had raised in its brief that, well, we really technically aren't bound by the rules of civil procedure in an evidentiary proceeding. We don't have to sort of dot our I's and cross our T's in terms of complying with Rule 18. Well, I would suggest that 2.06 would indicate otherwise. And I would also say that this really isn't an argument that they're not dotting I's or crossing T's. This is an argument about whether the chairman below is free to simply ignore the well-established law about recusing or referring, because that's what happened. It went out the window.
Do you have any case law that speaks to that issue?
Do I have any case law that says that 206? No, sir.
Okay.
206, unlike 18A, it has the phrase that any grounds for disqualification or recusal are conclusively waived if not brought to the attention of the panel within 10 days after they get the names and addresses. Mm-hmm. And of course, that's a different provision than in the rules of procedure. Does that give any guidance as to whether Rule 18A and B trump?
Well, if you go on to read the rest of 206, it says, however, grounds for recusal or disqualification not discoverable within the 10-day period may be asserted within the 10-day period.
But there's no evidence in this record. That's to the question you were asked earlier. Is there any evidence in this record of a ground that was not known for months? You talked about the lengthy months of delay of any information that was not known for months, and in all events, longer than 10 days after the names of the panel members had been provided.
Well, once again, that would go, this timeliness issue, whether there was evidence of timeliness, whether Judge Altman abused his, I'm sorry, Judge, the Chairman Altman, whether it was an abuse of discretion, you know, I think your question is, doesn't he have the discretion to decide that this wasn't timely?
That's practically the question. The question is 18A and B the requirement, or is 206 somehow different?
I don't think there is a substantive difference. I think 206 captures the spirit of 18A. And 18A, in this case, required either recusing or referring, and specifically said if you neither recuse or refer, what happens? Anything the judge does after that is void. And Mr. Davis tried to avoid that happening by setting it up on the record, which this board has been presented with, and saying, if you want to proceed, we're going to have a problem because everything from here on out is going to be void unless you take a step to recuse. Now, one of the arguments that the CDC...
We've gone considerably over the amount of time that we had allocated for this, and while the arguments are fascinating, and you've done a very good job of elucidating them, I think we understand at this point what the situation is. Ms. Hamilton, do you have anything that you would like to add?
No, I believe that the commission will stand on our response to the motion, and we've covered everything.
Very good. We will take this under advisement and notify you immediately of our decision. We appreciate your arguments. Thank you.